God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have one case scheduled for oral argument this morning, the case of Billy Joe Hoot Crawford versus State. Mr. Usman, are you ready?
Yes, Your
You may approach. We have allocated 20 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor, 5 minutes.
So noted, Madam Clerk, you may continue.
Thank you. May it please the court. Good morning. Michael Lefferman on behalf of the appellant Hoot Crawford, and I'll note that my client is present in the courtroom this morning. I'm hoping to focus my time this morning on two of the issues raised in the briefs, Claims 1 and Claims 3. And then, of course, if the court has any questions regarding the remaining claims, I'm prepared to answer those questions. Let me begin with Claim 1. The issue in Claim 1 is whether the trial court erred by granting the state's motion in limine that would prevent the defense from presenting testimony and argument relating to the legality of the shelter in this case. Now, my client was charged with interference with child custody, and an element of that particular statute, and that's 787.03, an element of that statute specifically says that at the time of the conduct, the public agency had lawful charge of the minor. Lawful charge of the minor. Now, there's no standard jury instruction for this offense, so the state prepared an instruction that was similar to what's contained in the statute. In fact, element 3, this is page 412 of the transcripts, specifically says at the time, PS, the minor in this case, was in the custody of a public agency having lawful charge of PS. But yet, even though that was, it's an element in the statute, even though it's an instruction that was read to the jury, the judge prevented defense counsel from making any argument that that element wasn't met, or from presenting any testimony that that element wasn't met. So in my briefs, I've relied upon what I believe is an analogous statute that involves resisting an officer. That statute is 84301. And in that statute, the legislature specifically said that at the time of the offense or the time of the activity, the officer must have been engaged in the, quote, lawful execution of a legal duty. Now, there was an issue within the Florida DCAs as to whether or not that lawful execution of a legal duty language was actually an element of the offense. This ultimately was addressed by the Florida Supreme Court in the Tillman case in 2006. And in Tillman, the Florida Supreme Court began by saying, when the language of a statute is unambiguous and conveys a clear and definite meaning, that meaning controls. The Florida Supreme Court went on to say that for that particular statute, 84301, because the legislature has placed the element of lawful execution of a legal duty within the statute, proof that the officer was acting lawfully is necessary in a prosecution for that particular crime. They said that this conclusion is consistent with precedent holding that such an element should not be defined in a manner that takes the issue away from a jury. And then ultimately they said, most importantly, the conclusion is consistent and effectuates the legislature's intent in making lawful execution of a legal duty an element of the crime. Everything I just said that came from Tillman would apply to this particular statute.
But here, counsel, did the dependency court extend the shelter order?
Yes.
Okay. What effect does the dependency court's extension of the shelter order have on your argument that DCF did not take lawful custody of PS?
Zero. My client wasn't even a party to the dependency case. So that has nothing to do with the criminal case. And more importantly, the legislature could have written into the statute that says if a dependency court finds that a shelter order is lawful, then that element of this statute is met. Obviously, there's no such language in this statute. What the legislature did say is that the state is required to establish that the public agency has lawful charge of the minor. So again, going back to Tillman, you look to the plain language of the statute, lawful charge of the minor. As the Florida Supreme Court said in Tillman, that type of language is proof that the legislature felt that that was a necessary element to prove the crime. That's consistent with the precedent that makes it so this issue is provided to the jury. You don't take it away from the jury. You actually let the jury make that decision. And most importantly, it effectuates the legislature's intent. What
Mr.
the-
Efferman, what do we make of the legislature including the 3 specific defenses to the charge?
Those are defenses, but they also, most importantly, said that as an element, the state must prove that the minor is in the lawful charge of the agency. Now, they could have simply said it is in the charge of the agency, but by including the word lawful, that lawful becomes an element. And to do anything other than that, what the state asked the trial court to do below and what the state is now asking this court to do is to rewrite the statute. This court should simply apply the plain language of the statute. But the state obviously recognized that. They drafted a jury instruction that included that as an element that was read to the jury. But then the judge, based on the state's request, tied defense counsel's hands behind his back and said, even though the jury is being told this is an element the state must prove, you can't present any testimony relating to that element. You can't even make an argument relating to that element.
But counsel, what evidence did the appellant have for trial that contradicted the dependency court's finding that an extension of the shelter order was necessary to protect PS?
So again, I think relying upon the dependency court is a red herring. There's nothing in this statute that says that in order to prove this offense, there's some relationship to a finding that the dependency court did or did not make regarding lawfulness of the shelter. So I don't think that's in any way relevant, but the issue was what evidence did defense want to present in this case, and what did they want to argue to the jury to show that this element, which again the state obviously agreed was an element because they cut it in the jury instruction, wasn't satisfied. And
What
this is
evidence did the defendant offer on that? What would the defendant have presented to demonstrate that the shelter was not lawful?
And this is on pages 225 through 235 of the record. This is the proffer that defense counsel made. The DCF supervisor acknowledged that in order for a shelter to be lawful, there must be a clear and present danger to the minor. So defense counsel went on to ask questions such as, was there any urgency at the Children's Advocacy Center, the CAC, on the date there was a decision made to shelter the child? There was questioning about, isn't it true that the parents, after this disclosure was made regarding the brother, actually placed the minor in intensive therapy? Isn't it true that the threats that were allegedly made by the brother weren't even made in Florida? They were made in Tennessee. So why is there any threat, clear and present danger threat, here in Florida when the threat was made in Tennessee? Was there any evidence that that the parents had placed the child in danger? And were there any alternatives to the shelter? These are all questions that defense counsel asked during the proffer. These are all arguments that defense counsel could have made. And in just going to the circumstances of this case, this was a voluntary interview, meaning that the state asked the minor to go to the CAC to give an interview. She did. She showed up voluntarily. She came with her lawyer at the time, and her lawyer said she's not going to answer questions alone. She wants to be with me. The child confirmed that she wanted her lawyer to be present for any of those questions. And at that point, they did not proceed with the interview, not through any fault of my client. And at that point, they then decided to shelter the child. What a strong argument for defense counsel to make, to say, ladies and gentlemen of the jury, an essential element of this case is that the shelter is lawful. We know what a lawful shelter means. There must be clear and present danger to the child. Well, was there a clear and present danger when they asked for the voluntary interview? What changed at the CAC to turn this from not being a clear and present danger to all of a sudden being a clear and present danger when she showed up voluntarily and there was no other information that was revealed? Now, that's a fact question for the jury to decide whether or not the shelter was lawful. But again, this judge didn't even allow defense counsel to make those arguments. It's an essential element of the offense. The legislature has said so. To read the statute any other way would be to rewrite the statute. And I know the three of you would never do that to a statute. You would apply the plain language of the statute. And again, the state acknowledged that. They put this as an element of the offense, but then they said, Judge, don't let them make any argument about it, and don't let them present any testimony. That's simply unfair. And for those reasons, my client should get a new trial where he is not prevented from presenting testimony and argument relating to what everyone agrees is an essential element of the offense. Let me turn to Claim 3. I will acknowledge, as I begin to address Claim 3, that I personally am frustrated by the way this was handled. I was the attorney that pursued this issue. I don't use the word gotcha lightly in briefs or in argument, but wow, I feel like this was a gotcha situation that I was the victim of. After the trial, after my client was convicted, he retained me. And one of the things that he also did is he retained an investigative firm to determine whether or not there may have been any juror misconduct. And within the 10-day time period after I got a report from that investigator, I filed a Rule 3.575 motion. I filed it timely. The rule says you must file within 10 days. In that motion, I said that during jury selection, defense counsel specifically asked, have any of the prospective jurors, have you been a victim of a crime, or have your family members been a victim of a crime? And a particular juror simply answered that I think some equipment was taken from his truck, but the juror investigation established, at least presumptively, we haven't had an interview to verify this, that actually that juror witnessed his wife being the victim of an assault or battery by the wife's brother while the brother was trying to remove the mother from a nursing home. That's a little too close to home with the facts of this case. The allegation is Mr. Crawford's trying to remove the minor from the CAC when there's potentially a shelter in place, and this juror witnessed his wife being the victim of an assault or battery by the wife's own brother while trying to remove the mother from a nursing home. So I filed the 3.575 motion. I said we meet the prima facie standard, which is a very low threshold to show that the three prongs of the test have been satisfied. It's relevant and material to jury service, it was concealed, and it's not due to any failure of defense counsel. We held a hearing on April 26, 2024. At that hearing, not one time did the state say, strike Mr. Ufferman's motion because it wasn't under oath or doesn't contain sworn allegations. Instead, we had argument about what the standard is, prima facie, have I met that standard, and the judge ultimately agreed and said, Mr. Ufferman, said to the state, what harm is there? I think we should move forward with the interview. Mr. Ufferman, if you'll please prepare proposed questions, hopefully we can agree upon those and pick a date. I picked a date. We were ready to have the juror interview. And the next thing I know, the state files a motion to strike my 3.575 motion after we've already had that hearing, and they say, oh, by the way, the motion wasn't under oath, doesn't contain sworn allegations, therefore it's insufficient. The state apparently did so because there was a judge in Bay County in a case called Drinkard who had issued a similar order striking a similar 3.575 motion. But notably, Judge Gay in the Drinkard case, although she struck it with prejudice and said the defense has the ability to refile within a certain period of time. So when I got that, let me back up a little bit. When the state initially filed the motion to strike and said it wasn't under oath, I replied and said, wait a minute, it's not required to be under oath. There's binding case law from the first DCA, the Ramirez case, that specifically explains that although the Florida Supreme Court has used language such as sworn allegations, they did so before the adoption in 2005, January 1st, 2005, of 3.575. This court in Ramirez pointed out that there's nothing in the language of 3.575 that requires sworn allegations. So I cited binding precedent from this court, but also cited two cases from the 4th DCA that, again, specifically address this issue and specifically say 3.575 does not require sworn allegations.
All right, and let me interrupt you. Has any DCA addressed the language in Joseph that, although may not be a holding in that case, seem to imply that sworn allegations are required?
I think the second DCA has addressed it in passing, but that's obviously not this court. This court in Ramirez very specifically, Judge Benton in his opinion, who was authored that opinion, was very specific about, well, yes, there's that language that's out there from the Florida Supreme Court, but obviously the Florida Supreme Court knows what they're doing when they adopt the rule. That language all predates the adoption of 3.575, and there's nothing in 3.575 that requires an oath.
Well, let me just stop there. Joseph was what year? I think 2022, right?
But Joseph is citing two previous cases that don't address, Joseph doesn't mention 3.575, and Joseph is simply citing to the cases that predated the adoption of 3.575.
But again, I think the salient point is Ramirez was decided in 2006, and we have, although not citing the rule, we have some discussion by the Florida Supreme Court. Should that at least be informative of our analysis here?
Not when it's not specifically discussed. I would concede if the Florida Supreme Court post-Ramirez, post-Gray and Pozo came out and said, let's be clear, even though the plain language of the rule doesn't require it to be under oath, and every other rule in the Florida Rules of Criminal Procedure, when they require an oath, say that it requires an oath. But let us be clear, we adhere to our previous language, and 3.575 motions require sworn allegations. That's never once been said by the Florida Supreme Court. They haven't considered 3.575 allegations at all. So this is simply, but putting all that aside, obviously I believe this court would either have to recede from Ramirez or I guess do some mental gymnastics to try to say that Ramirez has now since been overruled by the Florida Supreme Court, and without the Florida Supreme Court specifically even using the word 3.575 in an opinion, I find that hard to believe. But even if that were the case, just as the judge did in the Drinkard case, every Florida court that's addressed this type of situation has said when there's a technical deficiency, the striking of the motion should be without prejudice to refile. So what did I do?
Oh, and I need to stop you again, but so Joseph is talking about motions to interview jurors, right?
Not 3.575 motions. We have motions in post-conviction, we have motions in civil cases, but 3.575 are very specific 10-day motions that are filed after the verdict.
Okay, so that in your view just has no application whatsoever here.
I can't imagine the Florida Supreme Court wanting to somehow say that the fourth DCA got it wrong twice, this court got it wrong in Ramirez, and not even saying the word 3.575. And if they were, why wouldn't they, in such an opinion that I can imagine if I was drafting that opinion as a law clerk at the Florida Supreme Court and saying that, oh, by the way, we recognize that the rule that we adopted back in 2004 that became effective 2005 doesn't even contain the oath requirement. Therefore, we refer this matter to the Criminal Procedural Rules Committee. We think you need to amend the rule to add language that there should be an oath. So any practitioner, reasonable practitioner, who would actually read the rule would follow the requirements and do what's said under the rule. But putting all that aside, again, Florida law says that if there is a technical deficiency, that any order striking the motion on that basis should be without prejudice to give the defendant an opportunity to correct the deficiency. What did I do? The very next day, I resubmitted the motion. And I had an oath from my client, I had an oath from defense counsel that, again, met all the prongs.
I'm not sure I understand you. How do you reconcile Ramirez with the substance for the Supreme Court law, which appears to say sworn allegations are required?
Florida Supreme Court has never once said that 3.575 motions must be under oath. And the Florida Supreme Court adopted 3.575, which also doesn't say they're required to be under oath. But again, if that's true, conceding that that could be true, the judge had to give me an opportunity to amend. That's clear-cut Florida law. And then when I did amend, and I did it within 1 day, the state turns around and says, oh, strike it, it's untimely, it wasn't filed within 10 days. And that's the gotcha that I'm talking about. At that April hearing, the state didn't once say anything about the oath. They waited until numerous weeks have passed, clearly beyond the 10-day time frame, to file their motion. And even though Judge Gay in the Drinkard case gave the defense the opportunity to amend, and even though I did amend within 1 day, Judge Wells, after receiving the state's next motion to strike as being untimely, simply says, motion to strike granted, the motion wasn't filed within 10 days. How could it have been? And then I will point out also, 3.575 contains a good cause exception to the 10-day rule. I can't imagine a situation where there would be more good cause when any attorney, I consider myself somewhat smart, but any attorney in the state of Florida who would read the plain language of 3.575, follow those requirements, read Ramirez, read Pozo, read Gray, and then all of a sudden have the court come out and cite to a Supreme Court case that doesn't even mention 3.575, but say, oh, these allegations must be under oath, but then I'm not going to give you a chance to amend it, because any amendment would be after the 10 days? That's not fair. I mean, that's just not fair. So this case should be sent back to be put in the same exact posture that it was in. We now have a facially sufficient motion that is under oath. The judge has already granted a juror interview on this, and that's what should happen in this case.
Thank you, Mr. Elkman. But did the trial court give you an opportunity to amend?
Did the trial court give us an opportunity to amend? Right. Absolutely not. No. I literally amended the very next day. The state filed a motion to strike saying the amendment was untimely because it wasn't within 10 days of the verdict, and the judge granted that motion to strike.
And since the trial court did not give you the opportunity to amend, did the your amended motion relate back to the filing of the initial motion?
Yes, clearly. It's an amended motion that's only amended to include the two oaths that the judge said I had to include despite.
Without being given the opportunity to amend?
He did not give me an opportunity to amend. I think that's clear, Judge. I don't know. I want to answer any question you have about that. I filed the amended motion the next day. The state filed a motion to strike my amended motion because it wasn't filed within 10 days of the verdict, and the judge granted that motion, specifically saying the amended motion is stricken as untimely. It wasn't filed within 10 days of the verdict. If that's not gotcha, I don't know what is. If that's not completely unfair, not giving me an opportunity to amend when I actually did amend, and to not allow that amendment, that's not fair. And this, I believe we should get a new trial on ground one, or claim one, but at the very least, this should be sent back for a juror interview relating to claim 3. Thank you.
Thank you, counsel.
Good morning. May it please the court, counsel. I'm Darren Shippey. I represent the state of Florida in this matter. Addressing claim number 1, having listened to counsel's arguments on actually both claims, I can tell you that I disagree with what he says in both claims. And this court should disagree as well. And the questions that you've asked have been pertinent and on point. I disagree that the lawfulness of the shelter was an element of the offense of interference with the custody of P.S., the minor in this case. The more salient issue is whether or not Mr. Crawford had the lawful authority to interfere with that custody. And there's been no discussion about that, but that's actually an element of the offense that's set forth in the jury instruction as well as the statute itself. It doesn't take much time in the trial courts when you're in the courthouse there to recognize that there are these divisions. Generally, you've got a civil division, you're going to have a probate division, you're going to have a juvenile dependency division, you're going to have a criminal division. There's a reason that they do that, and each of them has their own responsibilities. What the defendant in this case wants to do is to have this court ignore the fact that we have those divisions and we have procedures set in place as to how we're going to deal with what the statutes require. So DCF, and they can complain all they want about what was going on, but there was a discussion between 2 experienced and knowledgeable DCF employees concerning what was going on. And the concern was not that the brother was up in Tennessee or that the allegations were in Tennessee. The problem and what was causing the issue with the minor in this case and the unusual emotional distress that she was experiencing was the fact that he was down here close to her. And that was driving her nuts, literally.
And you were able to present all of that to the jury, and you requested the instruction that included the lawful charge of the minor, text from the statute. I see that. And if, to the extent that we were to disagree with you that the lawful charge part is part of the an element of the offense that the state has to prove beyond a reasonable doubt, here, I think one of the wrinkles, and you're getting to it, kind of the divisions in the court, in a criminal case when we're looking at whether a law enforcement officer was exercising his legal authority, the criminal court can test that in the criminal case and can decide that. And here, the lawfulness of DCF's charge of the minor here is something that is primarily determined in the dependency court. But let's just take a hypothetical. Let's say a DCF official had just taken custody off work, knew nothing about this victim, and removed her from the Child Advocacy Center, had no authority. Would a defendant not be able to provide evidence to show that this person was off duty, maybe had even been fired, and clearly wasn't in lawful charge that the statute requires?
Not in the criminal trial, and what keeps getting overlooked is the statute applicable to sheltering a child, don't recall the number of it off the top of my head, specifically says that DCF, if they have a clearly observable danger, has the ability to shelter the child. We have to have that, but because we're going to look out for the best interest of the minor. We're not going to worry about what the defendant is doing. We're going to worry about the minor in this instance. But you know what? We're going to give him due process. So within 24 hours, that goes to the dependency court. That's where he should have gone if he felt that anything was improper. But they're kind of making it up as they go along when they get to a criminal trial, trying to say, you know what, notwithstanding the fact that we have a 16-year-old who's in emotional distress, who's not being protected by her parents, who's being allowed to be exposed to this dangerous brother, that you're supposed to ignore what the dependency court did. And not only did he have a hearing at that point in time, the parents did, it was extended for several weeks.
And I see your point. I think one of the things that it would be of concern in a case like this, if you were arguing about the lawfulness, you know, do some of the same standards apply in the context of a DCF official? For instance, you know, if they had a good faith belief at the time of the emergency shelter that the child was in danger, and it later, you know, is established that that was not founded, do we have a mini trial on those kinds of elements in the criminal case?
I think the defendant would have been able to raise that pre-trial if the fact that she had been improperly sheltered and was returned to her parents had occurred. The trouble is he doesn't have it. He doesn't have any bullets in his gun. He's got words and that's it. So you don't raise that in the criminal trial after that issue has been decided for the benefit of the child, clearly established. Once again, so I'm going to take issue with counsel that he says it's a red herring and has nothing to do. And I'm going to say it has everything to do with this case.
Sure. Well, assuming, again, if we were convinced that it were an essential element of the offense, what's your best argument on harmless error?
So they made a proffer at trial through, I think it was Bo Whitfield. The citations would escape me as to where it is in the record, but there's actually questions that were asked by trial counsel. And there was nothing that came out of that that established that the shelter was improper. Nothing. I felt that the proffer was completely anti-defense, if you will. It turned out that it didn't help him. So if the jury's going to hear that, it's clear that it wouldn't have had any impact anyway.
Getting back to the legal question, though, if lawful charge is an element of Section 787.031, then why shouldn't a defendant charged with interference with child custody be able to argue that the custody was not lawful?
For the reasons that I've already said. He could have addressed that in a different court before a judge that handled that matter. And if that went favorable to him, he could have brought that to the prosecution's attention in advance, and likely, perhaps, maybe the case, or at least that charge, goes away. But he didn't. And beyond that, he's a step removed. He's not the parents. He's a lawyer trying to insert himself improperly into what's going on and acting improperly in doing so. So that was ultimately going to be a problem, but if he felt that strongly about the fact that she was improperly sheltered, and beyond that, he conceded, if you listen to the recording, and what he kept telling everybody was, give me a court order and I'll turn her over. Well, you know what? They actually got that. Not only that, I think there was one delivered, if I'm not mistaken, at the scene, if my memory's good, and beyond that, he's got another one 24 hours later.
But if the dependency court had not extended the shelter of PS, could the state have still brought the interference with child custody charge?
Well, first of all, they introduced evidence that PS was properly sheltered. That was explained to the jury in testimony that if this concern exists, they have the ability to take her into protective custody. The defense counsel, in both the opening and the closing, concedes that she was taken into custody by DCF. So they don't dispute that, and they don't offer any evidence as to why it was unlawful. or what was improper about it. And they can't because it doesn't exist. They're arguing with nothing, is the bottom line. So you shouldn't assume that there was something out there. So to suggest that they didn't get to offer anything is to ignore the proffer that didn't establish that there was, it was Whitfield that explained what was the clearly observable danger. And what counsel is overlooking, and I don't want this court to overlook, is the fact that you have a distressed 16-year-old girl who's in close proximity to a brother who was threatened to rape her. That should get anybody's attention. And DCF is set up to protect our young people. And under those circumstances, what was occurring, because mom and dad were also at the CAC, they weren't giving any information or offering any comfort to DCF as to why DCF should not be concerned about that. This had nothing to do.
So to sum, your harmless error argument really is that the state offered legally sufficient evidence to meet the standard of proof required to show that she was in the lawful charge of DCF, and that the proffer that was, presented in the trial court was legally insufficient and adequate to overcome that.
Yes, we've easily established that if we assume that there was error, that the evidence that was introduced clearly established that there was a lawful shelter, as once again added to the fact that the mom testified as well and conceded on cross-examination that the shelter had been extended. There was nothing offered to show that there was not this clearly observable danger based upon the brother being close by in the same unit, as I recall. Not same unit like an apartment unit, but same complex, as I recall. And if the parents are playing both ends up the middle, but not protecting the one who's having the distress and having the mental emotional issues, that's a problem. That's why we have DCF to protect us under those circumstances. And apparently the dependency court thought that it was enough of a danger that she was sheltered for several weeks. So I would ask the court not to overlook that fact. And hopefully I've answered your question. Maybe not.
Yeah.
And once again, the issue is whether the defendant, as a lawyer, had the lawful authority to do what he did in interfering with that custody. And there hasn't been any discussion about that, but don't overlook that fact as well. And the state established that he did not. Moving on to...
interview question, counsel for the appellant argues our Ramirez decision. On that issue, why doesn't our opinion in Ramirez render erroneous the trial court's tracking of appellant's motion to interview juror E.V. for failure to include sworn allegations?
And you're leading right into where I was going with claim number 3. It's an interesting record below, with a motion being filed, a hearing being conducted, no written order being entered, and the judge simply saying, well, I never granted one of these, but I don't see what the prejudice is to the state. Seems a little wishy-washy as to whether or not we're really granting it, and there's going to be a lot of limits to it and things of that nature. So the state files a motion to reconsider that along with a motion to strike. Defense files a response to that. The order is then issued in writing. It's the only order it's the first order that grants the motion for reconsideration based upon there being unsworn allegations. Counsel's correct. Following day, an amended motion is filed. The state files a motion to strike that motion. Defense files a response to it, and then there's a subsequent written order that finds that the motion is untimely. All right, so I filed a notice of supplemental authority in this case. Hopefully you have received it. It was filed back on February 27th, and it is the second DCA in Dowd versus State, 227 Southern 3rd 194, that came out in 2017. You should read it because it addresses why Ramirez is really not the correct analysis, and it does that in a footnote on page 198, where it says that Mailer's reference to sworn allegations, that's a Supreme Court opinion, Baptist Hospital of Miami, Inc. versus Mailer from 1991, references sworn allegations, and because of that, acknowledges there seems to be some confusion over that. So you've got Ramirez in 2006 saying what it does. You got some other courts saying something else. But you know what's funny? Is you've never had the Florida Supreme Court issue an opinion where they haven't used the word sworn allegations. Well, why would that be? Because they expect there to be sworn allegations. And as counsel referred to, there's a couple different ways to bring something to the attention of the court. There's the ethical rules that are adopted specifically relating to that, and that's the way it used to be. But then this rule in 3.575 comes out and says what it says. But in that footnote 7, it explains why Ramirez overlooks the fact that when the court decided Mailer, Rule 1.431 had already been adopted. It did not require sworn allegations, and the Supreme Court continues to use the standard announced in Mailer, including the need for sworn allegations even when an interview is sought under Rule 3.575, and cites Crane, C-R-A-I-N, versus State at 788 Southern 3rd, 1025, 2011 Florida Supreme Court opinion. So it says that it seems unwarranted to assume that the Supreme Court intended to disavow the statement in Mailer. I cited Joseph in my brief. Once again, talks about having to establish prejudice along with sworn allegations. So I would suggest that this court should consider itself bound by the Florida Supreme Court's opinion after Ramirez came out, which would apply now. That would be Joseph, and find that there needs to be sworn allegations. Addressing the second part, it's funny that counsel used the word gotcha. I used the word gotcha as well on this same claim in the way that it was presented to the trial court. But more importantly, and I used the analogy of look at Rule 3.850, which contemplates a procedure and has in place a process that if you get it wrong the first time, then you're required to allow them to amend and file an amended motion for post-conviction relief. Doesn't exist in Rule 3.575. So the defense wants to get the benefit of the wording where it doesn't say sworn allegations, but they wouldn't ignore the fact that you're automatically entitled to amend your motion. And you're not. The rule doesn't say it. So if you're going to apply the reading of the rule, you got to use it against him.
And I think just the plain language of the rule at least has a legal sufficiency requirement. It may not rise to the level of sworn allegations, but it requires name of the juror, reasons that a party has to believe the verdict may be subject to challenge. And the Supreme Court has said that can't be merely speculative or conclusory, right? So we have that piece of it. So assuming you had a legally insufficient motion and it was filed, but there wasn't a sufficient motion filed within 10 days, this rule doesn't seem to have space for amendment, in your view.
That is correct. That is correct. And we could fast forward ahead a little bit to say that even though the judge granted the motion, there's nothing that would have been precluded the judge sua sponte from deciding, hey, you know what, I got it wrong, doing this on my own. I've had that happen to me before. I'm going to undo what I did. That can happen. So whether the state prompted it or whether the judge thought, you know what, that would really doesn't, I've never granted one of these things and probably shouldn't grant one in this case, takes the state up on its motion and, grants their motion. So in looking at the allegations, we're on appeal now. We're not in the trial court, so the defense has to demonstrate some prejudicial error in this instance. That's required by our statutes on the matter, showing that somehow or another the EB, who was the sixth juror, by the way, and also we can add to that, it's in the brief, the defense exercised no strikes, none whatsoever. State exercised 2, and there were 2 agreed upon challenges for cause. That's it. So I'll suggest to the court it's probably a little disingenuous to say after the fact, hey, you know what? Had I known that his wife was the victim of a criminal offense, even though it was a little kind of domestic, that he doesn't disclose. And once again, you got to show a concealment. That would suggest that he intentionally, the juror intentionally, did not disclose that. But he did disclose the fact that he was the victim. So it seems to carry more weight that personally being a victim is going to have more weight than someone related to you carrying that weight. But the defense would have to show that what was not disclosed, and I take issue with the fact that it was concealed, which is one of the elements, is going to vitiate the entire proceedings. That's kind of flies in the face of the record in this case. You exercise no strikes, you go hire a demonstrably prejudiced outfit to come in after the fact, and now you're going to say, hey, had I known that question, this answer is going to make all the difference in the world. That's refuted by the record. Don't buy into that. So having said that, I'll end with the same thing that I started with, which is Mr. Ufferman and I go back a long ways. I don't agree with what he's telling you, and I don't believe that the law supports what he's telling you, so I'm going to ask you to affirm.
But if the trial court erred in granting the motion to strike, then what would be the proper course of action? To reverse and remand for further proceedings?
As to the juror claim,
That is correct.
it would be to reverse, to send it back to the trial court to reconsider its motion if you're finding that he has the ability to file a late-filed amended motion. And I think to consider the motion itself. That's the way I would interpret the relief. Thank you.
Thank you, counsel.
I'm not sure how much time I have left in rebuttal.
It appears like you have 2 seconds.
Then I will say, respectfully, I disagree with my friend on the other side, and this court should reverse.
Thank you, counsel. This concludes our oral argument for this morning. We are adjourned.
All rise.